Good afternoon everyone. Welcome to this JISC Legal webcast entitled OER Legal Matters, coming live from Learning Services at the University of Strathclyde in Glasgow. My name is Jackie Milne and I'm a member of the JISC Legal team. Our aim this afternoon is to provide you with legal information and guidance to support your journey in the creation and dissemination of open educational resources. We want to help you put together all that hard work into materials that are legally compliant and truly open to the academic community and beyond. Although the webcast is principally focused on pilot projects that are part of the OER programme supported by JISC and the Higher Education Academy, we're sure that our webcast will also be relevant to any member of staff involved in OER. So, what will we be showing you today? Well, we have a variety of recordings, live presentations, interviews and question and answer sessions throughout the afternoon. We provided you with a programme for the webcast which you should be able to view on your screen now, and I will try to keep to that. The webcast is being recorded, so it will be available to you to download from our website a little later on. For those of you who don't know about JISC Legal, we're a legal information service. We work with staff in FE and HE to support them in dealing with legal issues that relate to ICT law. We now have an OER project page on our website where we will make available appropriate publications, announcements, FAQs and so on. However, enough about us. We want to hear from you too today. And under the video viewing window under me, you'll see a Your Questions text, which you can select to send in your questions to us here live in the studio. And we've allocated 2 slots where we will try to answer those. One is at the end of part 1 at about 2:45, and then we have a final panel discussion at about 3:50. We do value your feedback and we would appreciate it if you could complete the online evaluation. To do that, you simply click the feedback text which you'll see under the viewing window. And we're also offering a prize. This Sony ebook reader, which I believe has capacity for 160 titles, one lucky winner will be selected after the webcast. So don't forget to send us a completed online evaluation form with a valid email address at the end of the session. Okay, on with the programme. When we think about OER, we imagine resources being put together for educational purposes that are freely available for others to use, reuse in some cases, and share with others. So there are 3 main legal matters for us to consider. The first of these refers to accessibility law. Under the Disability Discrimination Act as amended, you as a member of an institution and provider of educational services have a legal duty to ensure that materials contained in the OER are accessible. Consider this at the planning stage, not further down the line where it could prove costly. This isn't something that you can ignore or wait and see. Rather, it's an anticipatory duty, meaning you must address it now before making those resources available to users. There's further information on accessibility law on our website, and there's a wealth of guidance available on our sister services site, JISC TechDis, from which you can access the link provided. The second relevant area of law that may apply to OER is data protection. One of the fundamental principles of the Data Protection Act 1998 is that any collection and processing of personal data must be done fairly and lawfully. This is the first principle in effect. Fair and lawful processing means that the individual to whom the data relates will have to be informed that their data is being collected, who will hold that data, what it will be used for, and who will have access to it. In other words, under the Act, to include personal data within an OER, you will generally need consent from the data subject. And where this involves sensitive personal data, that consent is likely to be explicit. So how do we know when we're dealing with personal data or not? This might be obvious where a person's face is clearly discernible in a photograph, for example, or a name, address, telephone number, etc. included, but it will to some extent depend on the context. A common name won't be personal data in itself. John Brown could be a number of people, but when taken with additional information, his job title within a particular institution, etc., this could identify the individual and will therefore, on the whole, be considered personal data. So other information that relates to that individual may identify them. What is important is on what basis the personal data was collected in the first place. If I took a photo of a student and told them it was purely for use in the classroom, that student might understandably object to their photograph appearing in an OER for the entire world to see. So an institution has three options when considering the inclusion of personal information. The first option is where you might choose to include the personal information without consent. You're taking a risk here, and this risk could be higher where that relates to sensitive personal data. This could lead to a complaint to the Information Commissioner and an enforceable action against your institution. This is not a position that institutions would want to find themselves in. The second option is where you don't have consent and you decide to therefore remove the material altogether. This is the potential to take something important out of a resource, and if it's not important, it probably shouldn't be there anyway. So again, it's not a satisfactory position. The third option is where you get consent. This is the safest route for the institution and will prevent any liability under the DPA. The third area of law pertinent to OER is, of course, IPR, or intellectual property rights, and in particular copyright law. And as we know, this is governed by the Copyright Designs and Patents Act 1988. As regards copyright, there are three main categories of materials that will be relevant for OER content. First, these may be materials where you own the copyright as an institution. In this case, you are free to do what you like with it. Second, you might be including materials where you don't actually own the rights, but you have permission or a license to use them. And third, the more trickier situation where you want to include third-party materials, but you do not have permission. We'll be looking at these three situations in more detail during this first half of the webcast.